So this is a transition moment in the course. We are still focusing on false advertising at the core, but now we will look at strengthening your ability to engage in issue spotting. This course will not fully prepare you to answer all relevant class action questions. Um, Instead, we're just trying to give you a sense of the issues a class action could face in the false advertising space. Currently, there are a lot of the cases over natural claims on food. Um, One question that people often ask is this just overreaching by greedy plaintiffs' attorneys? A more neutrally phrased version of the question is, who's the best representative of consumers' true interests, and do class actions add good things to the mix? Also note that the clusters of claims that exist may be generated not because of their own inherent characteristics, but because of the claims that can't be brought. So one reason we see a ton of food claims is that other barriers to class actions like arbitration agreements exist. The plaintiff firms that used to sue AT&T didn't go away. They instead found other things to sue over, things where arbitration agreements generally aren't signed. The key belief driving almost everyone's thinking about class actions is if the class action is certified, then there will be almost certainly a settlement. And the only question is, what will the settlement look like? The reality on the ground seems to be changing. Certification is not the end for a fairly large percentage of cases, but the perceptions haven't. And judges who have these perceptions may shape their analysis of whether a class action is appropriate around that perception. So in the materials, we talk about the increasing barriers to class actions. And here I just want to emphasize the 1-2 punch of mandatory arbitration and ascertainability. The Consumer Financial Protection Bureau was previously considering whether to ban or limit consumer arbitration clauses in consumer financial product contracts, as it is statutorily empowered to do. The Trump administration put that on hold. And anyway, even if that happens, most consumer products aren't financial products. So unless the FAA as a whole is amended, this will probably continue to be a huge barrier. On the other side is ascertainability, which neatly enough deals with situations in which there isn't a written contract almost entirely. So the Third Circuit has held that without receipts held by most of the relevant consumers or records held by the defendant, then there can be no class action because the class is not reasonably ascertainable. Other courts to date have usually rejected the argument at this extreme a level, but defendants will keep raising it in every jurisdiction until there's a Supreme Court case resolving the issue. There's probably nothing that regular consumers don't buy that doesn't fit into one of these categories or another. That is, there's a contract, or it's the kind of product that people don't really keep receipts for, and companies don't keep records of who bought it. So if the Third Circuit view were to prevail and the law of arbitration doesn't change, that'll basically be it for consumer class actions. Another federal law of note, the Class Action Fairness Act of 2005, which federalized a lot of class actions, provided for easy removal in most cases, limits on attorney compensation, and limits on settlements. Most federal courts then denied nationwide classes on the theory that state laws vary too much to allow a nationwide class. So even the cases in federal court often cover a small set of states. A handful of states are the big hitters, like California, New York, Massachusetts, and Illinois. But for each one of those, you're going to need a putative class representative from that state to invoke that state's law. Empirically, if there's enough money on the table, state-by-state litigation does still occur, perhaps contrary to the expectations of CAFA's drafters. We're going to focus a lot on California for several reasons. First, as of 2018, nearly 40 million people lived there. It's a large country and economy all on its own. The volume of litigation is quite high, and the consumer protection laws are relatively protective. By initiative, Californians did amend their consumer protection law through Proposition 64 to end private attorney general actions by plaintiffs who hadn't themselves been harmed by false advertising or other unfair competition. So what that did is it took away the kind of plaintiff you could get out of Nike in Nike versus Kasky, who was just suing on behalf of the public, even though he hadn't bought the shoes themselves. So Kasky could no longer sue. However, anyone who claimed to have bought shoes in reliance on Nike's advertising about its labor practices would still have standing to sue. So the California Supreme Court interpreted Proposition 64, requiring lost money or property from a private plaintiff in the cases called the In Re Tobacco 2. These are cases about long-term advertising of cigarettes. And the key rule coming out of these cases is that only the representative plaintiffs have to meet the injury and standing requirements. You don't have to show that every member of the class does. Reliance is a component of injury. It can also be understood as a causation requirement, that it was the false advertising that in some way caused the loss. The California Supreme Court then says that reliance can be presumed when misrepresentation was an immediate cause of the consumer's action. In other words, the consumer has to show a reasonable probability that the decision would have been different without the falsity. The falsity need not have been dispositive. So we're looking for a cause rather than a necessary cause. The presumption, or at least the court says, an inference of reliance will result if the misrepresentation at issue is material. In another Tobacco 2 rule, less important, less often successfully invoked, is that when an ad campaign is relatively uniform and long-term, the plaintiff doesn't have to identify which specific ads they saw in order to say that the claim affected them. But this doesn't work for very many plaintiffs. It's just for cigarettes. We're talking about really decades-long messages. In terms of what constitutes lost money or property, one of the most interesting issues under California law is whether it is enough that you bought a thing that you would not have bought absent the misrepresentation, even if you paid the market price for the thing, right? So if there was no price premium. The moral injury of disrespect for the consumer's autonomy would ordinarily make this enough of an injury, but that's not lost money or property. So the California Supreme Court, in deciding a case about whether falsely advertised discounts, where the product allegedly was not actually discounted, it was just always sold at this low price, says the allegation that it changed the purchase decision is enough to allege lost money or property. The court says that paying for an advertised product, even a functional one, is an injury because you didn't get what you paid for if you were affected by the false advertising. So this is a purchase you wouldn't have made without this, counts as lost money or property, even though you might have made some other purchase. The question we should talk about in class is whether that should always be true. The counterfeit Rolex in the court's example lacks resale value, and I myself, if I try and resell it, I might be in some legal jeopardy myself. And as an observant Jew, I'd have to throw out the non-kosher meat, which again is not going to have any resale value. But query whether that's always true. So something to consider for class is, suppose I'm at the store and I want yogurt and I pick the one that says it's probiotic for digestive health. As it turns out, it doesn't support digestive health. That's not true. But I was going to have yogurt anyway. So if there is no price premium, what exactly is my loss from picking falsely advertised yogurt 1 over identically priced but not falsely advertised yogurt 2? So I look forward to seeing you in class, and we can talk about this and other issues.